Welcome back to Artificially Informed, the podcast series that offers an in-depth look at the Florida Attorney General's Government in the Sunshine Manual, 2025 edition. I'm Joel Chandler, and as always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and review and edit all of the output. In today's episode 10, we're continuing our exploration of Part 2, Public Records, specifically B, what entities are covered, Application of the Public Records, Act 2. We'll be navigating pages 66 through 72 of your manual. Our discussion will focus on the detailed application of the Public Records Act to the judiciary, the legislature, the governor and cabinet, and finally commissions created by the Constitution. Following the exact outline of your manual, as we're going into detail, this episode will be longer than our usual 15 minutes. Let's pick up where we left off, delving deeper into the judicial branch and its records. Segment 1B, what entities are covered? Judiciary, rules and confidential records, pages 66 to 67. We finished episode 9 by introducing 3. Judiciary on page 66, noting that the Public Records Act, Chapter 119, generally doesn't apply to the Florida Judicial Branch. This is because the courts have their own inherent power to manage their records. So again, A, Public Records Act, inapplicable to judicial records, 3.A, on page 66 means Chapter 119 doesn't directly tell the courts how to handle their records. However, as we also mentioned, that certainly doesn't mean judicial records are secret. They are still largely public, but under a specific and distinct set of rules established by the Florida Supreme Court. This leads us to B, public access to and protection of judicial branch records, 3.B, which begins on page 66. This is a very important rule directly issued by the Florida Supreme Court, specifically designed to govern public access to all judicial branch records. It effectively acts as the judicial branch's own comprehensive public records law. Let's break down Rule 2.420. We started with its one scope of the rule, 3.B.1, on page 66. This part clarifies what kinds of judicial records Rule 2.420 covers. It applies very broadly to all records held by the judicial branch. This includes records from the courts themselves, records from court administration offices, and records from any other judicial agencies. The rule aims to strike a careful balance between ensuring public access and protecting the need for confidentiality in certain judicial proceedings or specific types of personal information found within court files. It's their framework for transparency while acknowledging the unique nature of judicial work. Now let's move to page 67 to discuss 2, confidential judicial records, 3.B.2. Even though the general rule is public access, Rule 2.420 does identify specific categories of judicial records that are confidential or exempt from public access. The manual on this page will list these specific types of confidential judicial records. These exemptions are usually put in place to protect sensitive information, such as confidentiality necessary to protect a person's privacy. This often includes information like social security numbers, bank account numbers, or certain medical and psychological records, which could lead to identity theft or undue intrusion if made public. Information that could jeopardize the safety of individuals. This might apply to victim or witness identities in certain sensitive cases. Confidentiality required to ensure the integrity of judicial proceedings. This could involve grand jury information, certain juvenile delinquency records, or ongoing investigative records not yet part of public proceedings. It's crucial to understand that these confidential categories are specifically defined within Rule 2.420 and are not to be broadly interpreted. Just like with Chapter 119, the presumption is openness unless the rule explicitly states otherwise. The rule generally outlines these categories to provide clear guidance to clerks of court and other judicial personnel on what information must be protected. Segment 2, B, what entities are covered? Judiciary. Procedures, discovery, Florida Bar, JQC, JNC, pages 68 to 69. Continuing our detailed look at the judiciary, we move to page 68. Here are the manual outlines, 3. Procedures for accessing judicial branch records under Rule 2.420 3.b3. This section is important because it tells you how to actually get judicial records. While the core principle is public access, there are specific steps to follow. Generally, requests for judicial records are made to the clerk of the court where the records are located. The rule sets out the process for submitting requests, the timeframes for response, and what happens if a clerk denies a request, including a review by a chief judge. It also covers methods of access, whether it's physical inspection or obtaining copies, and any allowable fees. Also on page 68, we find a C, Discovery Material 3.c. This refers to information or documents that are exchanged between parties in a lawsuit during the discovery phase. While discovery materials are part of a court case, the Public Records Act typically doesn't apply to them unless they are filed with the court and thus become part of the court's official records. Before filing, they are generally considered private between the parties, but once filed, they often become public under Rule 2.420 unless specifically sealed or deemed confidential by court order. Moving to page 69, the manual addresses the D Florida Bar 3.d. The Florida Bar is the official organization that licenses and regulates attorneys in Florida. Its records are generally considered public records under Chapter 119 of the Florida statutes unless a specific statutory exemption applies. However, some aspects of attorney disciplinary investigations are confidential until certain stages of the process are reached, as outlined in the Florida Bar Rules of Procedure. This is a common area where the public's right to know balances with the need to protect ongoing investigations. Also on page 69, we cover E2 Judicial Qualifications Commission and Judicial Nominating Commissions, 3.e. The Judicial Qualifications Commission, often called the JQC, is the body that investigates complaints against judges. Records related to its investigations are typically confidential until formal charges are filed, or in some cases, until a recommendation for discipline is made. This confidentiality protects the integrity of the investigative process and prevents premature damage to a judge's reputation before findings are conclusive. Judicial Nominating Commissions, or JNCs, are groups that screen and recommend candidates to the governor for judicial appointments. Their records related to candidate applications and deliberations are largely confidential, particularly during the active screening process. This is designed to encourage highly qualified individuals to apply without fear of public scrutiny of their private information during the early stages of selection. However, some final lists or recommendations may become public at later stages. Segment 3, B, what entities are covered, judiciary, jury records, and sunshine and litigation, pages 70 to 71. Continuing with the judiciary, let's look at page 70 to discuss F jury records 3.f. This covers records related to both grand juries and trial juries. 1. Grand jury 3F1 records on page 70 are almost universally confidential. A grand jury is a group of citizens who decide whether there's enough evidence to bring criminal charges. Their proceedings, testimony, and records are kept secret to protect witnesses, prevent suspects from fleeing, and ensure the integrity of investigations. This confidentiality is critical to the grand jury's function. 2. Trial jury 3.f2 records, also on page 70, refer to records related to juries in criminal or civil trials. While the jury selection process, known as voir dire, is generally open to the public, some identifying information about jurors might be kept confidential to protect their privacy and safety. The deliberations of trial juries are also secret. Finally, on page 71, we have G, Sunshine and Litigation Act, 3G. This act, found in section 69.081 Florida statutes, is really important because it impacts public access to records involved in settlements of lawsuits, especially when public safety is on the line. Essentially, it prevents the sealing or confidentiality of court records or settlement agreements that involve public hazards, Let's break that down a bit more. This law says that if a settlement or a court record contains information about a product defect like a faulty car part or a dangerous household appliance, an environmental hazard such as pollution that affects public health, any other condition that poses a public danger, this is a broad category meant to catch anything that could harm the public. If this kind of information is present, then that information cannot be kept secret, even if all the parties involved in the lawsuit agree to try and seal it. The law prioritizes public safety and access to information about potential dangers over the desires of the parties to keep things confidential. This means the public has a right to know about things that could affect their health or safety, regardless of a private settlement agreement. This ensures that dangerous information comes to light, potentially preventing future harm to others. Now let's talk about how the Sunshine in Litigation Act specifically affects agencies. No hiding public hazards in settlements. The most direct impact is that if an agency is involved in a lawsuit, they absolutely cannot agree to confidentiality clauses in settlements or proposed court orders that would hide information about a public hazard. This means an agency can't make a deal with another party, for example, a company they're suing or that is suing them, to keep quiet about a faulty product, a dangerous condition, or environmental pollution if that information poses a risk to the public. The law steps in and says, no, public safety information cannot be sealed. Duty to resist sealing orders. Agencies have an active duty to ensure that any court records or settlement agreements pertaining to a public hazard are not sealed by court order. If another party tries to get such records sealed, the agency must typically object. They are effectively mandated to advocate for transparency in these specific instances, aligning with the broader public policy of open government. Impact on legal strategy. This significantly shapes how agency lawyers approach litigation, especially settlement discussions. They have to keep this law firmly in mind from the very beginning of a case, knowing that certain types of information, if they constitute a public hazard, cannot by law be kept confidential. This pushes agencies towards transparency about risks to the public. Records remain public, regardless of source. If an agency happens to possess records that reveal a public hazard, even if those records originated from a lawsuit or a settlement where confidentiality was attempted, the Sunshine in Litigation Act helps ensure they remain public. So, for instance, if a county health department obtains a document as part of a lawsuit settlement that details a hazardous waste leak affecting the community, that information would likely still be accessible to the public despite any attempts to keep it secret by the private parties involved. Reinforces Public Records Act. This act essentially reinforces the broad definition of public records to specifically include information about public hazards that might otherwise try to be protected under other litigation-related exemptions. It's a very specific carve-out designed to ensure critical public safety information always sees the light of day. Implicit encouragement for proactive disclosure. While the Act doesn't necessarily force an agency to proactively publish every detail, it certainly removes a common legal barrier to access for the public and media who are looking for information about potential dangers. By making it clear that certain information cannot be confidential, it indirectly encourages agencies to be forthcoming about public hazards. How is the Sunshine in Litigation Act enforced against agencies? Enforcement primarily occurs through the courts. Any person, whether it's a private citizen, a media organization, or any interested party, has the standing to ask a court to enforce the provisions of the Sunshine in Litigation Act. This means you don't have to be a direct party to the lawsuit or show a special interest beyond being a member of the public. If a settlement agreement or a court order attempts to seal information that falls under the public hazard definition of this statute, a lawsuit can be filed to challenge that confidentiality. The court then has the power to invalidate the confidentiality provision. A court can declare that the part of the settlement agreement or court order that attempts to keep the public hazard information confidential is null and void. This effectively unseals the information, making it accessible to the public. Order disclosure. The court can directly order the agency or any party holding the information to make the public hazard information available for inspection and copying. Injunctive relief. A court could also issue an injunction preventing future attempts to seal similar information related to public hazards. Essentially, the law provides a clear pathway for the public to ensure that agencies cannot use litigation or settlement agreements to hide information that directly affects public health, safety, and welfare. It places the ultimate responsibility on agencies to uphold this transparency even when faced with pressure from other parties in a lawsuit. So, in essence, the Sunshine and Litigation Act acts as a powerful safeguard, preventing agencies from being complicit in secret agreements that could endanger the public. It ensures that information about public hazards, even when tied up in legal proceedings, ultimately remains a matter of public record. Segment 4B. What entities are covered? Legislature, Governor, and Cabinet Constitutional Commissions, pages 71 to 72. Now let's shift our focus to other branches and entities covered by the Public Records Act, moving to page 71. We look at 4, Legislature, on page 71. The Florida Legislature, which is the state's lawmaking body, is generally subject to the Public Records Act. Records of legislative committees, staff, and legislative proceedings are typically public records unless specific statutory exemptions apply. This means that bills, committee reports, correspondence related to legislative duties, and even many internal communications are accessible to the public. This ensures transparency in the lawmaking process. However, some deliberative or preliminary legislative records might have temporary exemptions to protect the legislative process, but the general rule is openness. Moving to page 72, we find 5. Governor and Cabinet, the Governor of Florida and the Florida Cabinet, which acts as a collegial body on certain matters, are also subject to the Public Records Act for records made or received in the transaction of official business. Records from the governor's office and cabinet agencies are generally public. This includes official correspondence, policy documents, and records related to their executive functions. As with other agencies, specific statutory exemptions might apply to certain types of sensitive executive records, but the fundamental principle is that their records are open to the public. Finally, on page 72, we have 6. Commissions created by the Constitution. Florida has several commissions established directly by the Constitution, such as the Fish and Wildlife Conservation Commission, the Public Service Commission, or the State Board of Education. Records made or received by these constitutionally created commissions in the transaction of their official business are public records under Chapter 119 of the Florida statutes. This ensures that even high-level commissions, whose authority comes directly from the state constitution, operate with transparency regarding their records. Their records are treated much like those of other state agencies, subject to the same rules of public access and any specific statutory exemptions. This concludes our detailed exploration of B, what entities are covered in the Public Records Act, taking us through page 72 of your manual. Thanks for listening. In our next episode, episode 11, we'll shift our focus to C, what records are covered, starting on page 73, where we'll delve into specific types of records like adoption, birth, autopsy, and death records. Until next time, remember, the truth dies in the dark, so let's leave the light on.